incorporators, stockholders, and members. When it comes to corporators, what's the difference between corporators and incorporators? Corporators, those are composed of corporation, whether as stockholders or shareholders in a stock corporation or as members in a non-stock corporation. So again, when it comes to corporators, these are corporation compose a corporation, whether stockholders or shareholders in the stock corporations or members in a non-stock corporations. So they are holders. These refers to holders only, holders or members of a non-stock. If we say stockholders, it refers to a stock corporation. If we are saying members, it refers to a non-stock corporations. How about incorporators? Incorporators are those stockholders or members mentioned in the articles of incorporation, AOI, as originally forming and composing the corporation and whose signatories thereof. So the very are those mentioned named in the articles of incorporation. So those names mentioned in the articles of incorporation composing the corporation is they are called as incorporators. Okay? And their signatures affixed thereof. So again, when it comes to corporators and incorporators, incorporators are mentioned in the articles of incorporation originally forming the corporation, while those corporators, they are only buying the shares, being members of a non-stock, diba? They are shareholders, buying some shares of a corporation, or entering as a member to a non-stock corporations. So, when it comes to number and qualifications of incorporators under Section 10, stockholders or members originally forming the corporations are mentioned and signatories in the articles of incorporation. So, for stock corporation, incorporators in a stock corporation, any person, partnership, association, or corporation, if natural person, must be legal age. Again, when it comes to stock corporation, any partnership, um, any person, first, any partnership, any association, or any corporation, for natural person must be of legal age. They can. Then, it can be singly or jointly. Then, not more than 15 members. Not more than 15 in numbers. It means to say there can be 15 persons, there can be 15 partnerships, 15 associations, or 15 corporations to compose incorporators. So it means to say only 15 in number. If you will be asking if there can be a mix, yes, there can be a person, partnership, corporation, association, provided they are only 15 in number. Not for the purpose of practicing a profession. If we say practicing a profession, then that is already GPP, the General Partnership Profession, or General Profession, General General Partnership for Practicing Profession, GPP, unless otherwise provided under special law, unless otherwise provided by special laws. No Philippine residence requirement, even foreigner, even a mix, even a Filipino or foreigner, they can form as incorporators. A corporation with a single stockholder is considered a one-person corporation, the OPC. Okay, so if there is only a single stockholder, even though one single stockholder can be can have an incorporations, di ba? That is already one person corporation. Even you, single stockholders, can go to the SEC, Securities and Exchange Commission, to register your corporation, your OPC, one person corporation. Next, incorporators when it comes to non-stock corporation. Recently, those are stock corporation. Now, non-stock corporation. So these are members, diba? For stock corporation, they are called people there are called as stockholders, shareholders because they buy shares, diba? But when it comes to non-stock, they are being called as members. Any person, partnership, association, or corporation because they have juridical entity. They have the legal entity. They are considered as person. Person, human being, natural person. Partnership, association, corporation, they have juridical entity. So they have the legal entity. If they are registered under Securities and Exchange Commission, then they are called as juridical person. Next, if take note, if for person must be of legal age, must be 21 years old and above. Singly or jointly, may be more than 15. So this is the opposite to the stock corporation. When it comes to stock corporation, only 15. 15. But when it comes to non-stock corporation, it can exceed 15 persons unless provided by the rules, the RCC or other special laws. Not for the purpose of practicing a profession, not GPP, and no Philippine residence requirement. That is for incorporators. When it comes to non-stock corporations but educational corporation, diba? As we have said, as we have classified kinds of corporations under non-stock corporation, there can be educational corporations and religious corporations. So for non-stock, for educational corporate institution rather, educational institution, any person, partnership, association, or corporation, if natural person must be of legal age, not less than 5 nor more than 15. Then not less than 5, not more than 15. So when it comes to stock corporation, not more than 8, not more than um, 15, but there can be one that is OPC, one person corporation. But when it comes to educational institution, not less than 5, so therefore from 5 to 15, not exceeding 15 persons. 15 in number, provided that the number of trustees shall be in multiples of 5. So it means to say the trustees must be in multiples of 5. There can be 5, 10, 15. Diba? Number of trustees. And the same also, no Philippine residence requirement. So, qualifications. These are the qualifications. So, for qualifications of incorporators in a stock corporation, he or she must have at least one share. Diba? Must own at least one share of the capital stock. I'm gonna say that is must own at least one share of the capital stock. From the entire capital stock, a shareholder must have at least one share from the capital stock, or must be a subscriber to at least one share of the capital stock. A shareholder or a subscriber, di ba? Must own at least one share or must be a subscriber for at least one share. That is for stock corporation. But when it comes to non-stock corporation, must be a member of corporation. Next, qualifications. These are now the qualifications when it comes to natural person, partnership, domestic corporation or association, or and foreign corporation. When it comes to natural person, it must be that person must be of legal age. When it comes to partnership, must be registered with the SEC, and partnerships and those those that cannot be incorporators if they are disqualified if they are partnerships under dissolved or expired status with the SEC. So again, for partnership, they must be registered with the SEC. Otherwise, they are not allowed. For domestic corporation or association, still the same, must be registered with the Securities and Exchange Commission. But when it comes to domestic corporations under delinquent, suspended, revoked, or expired status with the SEC, cannot be. Cannot be a member of incorporators, cannot be one of those incorporators if these corporations or associations are delinquent. Domestic, if we are referring to domestic, if they are delinquent, suspended, revoked, or expired status with the Securities and Exchange Commission. But when it comes to foreign corporation, they must be registered only with the Securities and Exchange Commission, with the SEC. So again, for natural person, it must be must be of legal age. For partnership, association, and corporation, they must be registered with the um, Securities and Exchange Commission unless um, ah, provided they are not disqualified, their registration is not expired, dissolved, suspended, or revoked. Next will be the documents needed. Documents needed and the content of that document. In partnership, there must be a partnership's affidavit. That's the document needed by the partnership. The content will be executed by all the partners. It's it's obviously partnership. It must be executed by all members, by all partners, to the effect that that they have authorized the partnership to invest, and that they have designed or designated one of the partners to become a signatory. Ba? Must be executed by all parties, by all partners, to the effect that they have so that to the effect that they have authorized the partnership to invest, that they have designed one of the partners to become a signatory. So it should be executed by all. These partnerships affidavit must be executed by all and authorize partnership to invest, uh, or designate a partners to be a partner to be a signatory in or in corporations, to be a signatory in the articles of incorporation. Next will be for domestic corporation and association will be the directors and trustees certificates and secretaries certificate. Secretaries certificate. Directors or trustees certificate or secretaries certificate must be executed under oath, and must indicate that it was approved by a majority of the board of directors. So that certificate must be executed under oath and must be voted, or must indicate that it was approved. Must indicate that it was approved by majority of the board of directors, majority of board of directors or trustees, and ratified by the stockholders representing at least two-thirds of the outstanding capital stock of or of the members, as well as the authorized signatory. So this is for corporation and association. It must be the directors or trustees certificate must be um, under oath, diba? Executed in under oath, and must indicate that it was approved. It must indicate that it was approved by majority of the board of directors or trustees. and ratified by the stockholders, representing at least two-thirds of the outstanding capital of the members as well as the authorized signatory. While for a foreign corporation, document duly authenticated by Philippine consulate or with an apostille affix, apostille affix, authority of the foreign corporation, in which the foreign corporation must have the um, a document duly authenticated by the Philippine consulate or with an apostille affix, authority of the foreign corporation to invest in the corporation being formed, the authority of foreign corporation to invest in the corporation being formed and specifically naming the designated signatory on behalf of the foreign corporation. The same, the same also with the other requirements in which it that document authorized that corporation to invest in the corporation and to designate a person to be part of the signatories. So again, these are the documents needed as a qualification to be an incorporator. First, for partnerships, there must be a partnerships affidavit. It must be executed by all of the members, by all of the partners, to authorize to invest to a corporation and to designate a person to be the signatory in the AOI. While for domestic corporation, there must be directors or trustee certificate or secretary's certificate, which it must indicate must be executed under oath, must be executed under oath, um, must be executed under oath, and it must indicate that there is a approve of majority. By a majority, there must be the certificate is approved by majority of all the members. Not majority of board of directors. Or as this is majority of board of directors and trustees, and first must be duly executed under oath. Second, there must be an indication that there is approval by a majority of board of directors and trustees and must be ratified by at least two-thirds of the majority of the outstanding capital stock or of members, as well as the authorized signatory. Next will be the a document certified, duly certified or authenticated by the Philippine consulate or with an apostille affix, wherein authorizing the foreign corporation to invest to a corporation, authorizing the foreign corporation to invest to a corporation and specifically designating the name of the signatories on behalf of the foreign corporation. So these are qualifications, some of the qualifications of incorporators.